a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, it is that time of the week. David Whiting, Melbourne solicitor, joins us. He hasn't sashayed into the studio, but he's sashayed into his own home office and taken a seat and joined us down the line. David Whiting, good morning.
Good morning, Ali.
How are you?
I'm very well, thank you.
Excellent.
Taking a day at a time.
Yes, well, that's a very good way of taking it. And you will be very pleased to know that unlike last week, the Premier has decided to hold off until the end of your segment for his daily
He
press
must have
conference.
heard.
I'm sure he did.
Yep.
Either that or he got an email from you, one or the other.
Yes.
So did you have homework? I think you did.
No, I didn't.
You
Didn't have any
didn't?
homework. We're homework free.
Homework free. Okay. 1300 222 774 is the number if you would like to speak with David. Alex in Collingwood. Good morning, Alex.
Oh, good morning, Ali. Good morning, David. First of all, go Richmond. And secondly...
We can't adjudicate on that.
Look, I live in on a property that has a shared driveway with a neighbour. And we're in the process of trying to create an easement. There was an informal easement before because the Border Works sewage drain ran through there. So we're in the process of doing that. And the neighbours can't seem to find their title because the lawyer they had it with has passed away. What would the process be to try and find that title? There hasn't been a mortgage on the house for 30 years.
David? Oh, I think that it's all right, Alex. It's not you. I think we've lost David there. We will get David back. I'd love to say that I could answer. I'm probably better at having a go at you about Go Richmond than I am about telling you about title searches and what the process
It's unfortunate
is.
Melbourne didn't make the finals. I was hoping they would.
Yes, I do. Look, I feel very, very much for those Melbourne supporters who have tried so very hard for such a long time and they were so close. But never mind. But do you reckon Richmond's in this year?
I do, and I'm really more like a Footscray supporter. I'm always very nervous.
You and everyone else. Now, Alex, David Whiting has joined us again. David, did you hear Alex's query?
No.
Oh, okay. Alex, give us a quick précis again.
All right. I'm in the process of creating an easement on a shared driveway with the neighbours, and they don't have a mortgage on their house. So they were trying to find their title, and they don't seem to be able to find it. Apparently the solicitor that had it passed away. So what would the process be after that?
There's a process for making an application to Land Registry for a replacement certificate of title.
Yes.
So I would actually be doing two things. I would be contacting the Legal Services Board, and they will tell you which firm of lawyers is holding the records for the lawyer who passed away.
Okay, so there's a record.
Well, there's generally a record. It's not universally right, but there's generally a record. So, I've had a couple of practices that I've acquired over time. So the Legal Services Board shows me as the acquirer of those practices and generally the holder of those records. The other thing that you would do is you can make a title search from the Land Registry. It's called an issue search.
Oh, okay.
And the issue search is advice from the Land Registry telling you who they last provided the title to. Now, it might be a bank on a discharge of a mortgage, or it might be a lawyer.
Right. Okay, fantastic.
Okay.
And in the event that you can't find the title, there's a process for applying for a replacement. Probably fees of about $400 is what it will cost you, plus whatever process. What process? About a fortnight.
Okay.
All right, Alex, well, good luck and may the best team win the grand final, given that you managed to get a little plug in there. 1300 222 774 is the number if you'd like to speak with David. Claire has joined us from Melbourne. Hi, Claire.
Hi, Claire.
Good morning, Claire.
Hello.
Yes, you're on. What would you like to ask David?
Thank you, David and Ali. Okay, so my father's an 85-year-old pensioner. He's got a reverse mortgage of approximately $150,000 with compounding interest. My sister and I want to pay for this as we have the cash. What legal advice should we get as far as, putting a caveat on the property so he can't mortgage it out again? Will there be any implications with his Centrelink? He's also got a younger girlfriend not living with him. Would she have a claim on his estate in the future? Also heard about the granny flat rule. If you could help me with those sorts of questions, please.
Okay, wow, that's a bundle. If you were going to be taking over the reverse mortgage, and you just wanted to be an abundance of caution, the caveat wouldn't prevent him getting another mortgage. What you would want to do is you would want to have a mortgage with him.
Okay.
So you, in a sense, you become the new lender. You become the new financier, and you lend him the amount of money that he requires to pay out his existing mortgage.
Okay.
And you take security.
Right.
Okay. So you may or may not choose to charge him interest. Let's assume you don't. Then you would simply take out a new mortgage for the $150,000, where you would be the lenders and he would be the borrowers. And it means that the first mortgage to the current lender would just simply disappear. It would have no Centrelink consequences.
Okay.
The younger girlfriend, who doesn't live with him, the question will be whether a court, when he dies, would consider that he had a moral obligation to provide for her. Now, the normal expectation is that we look after people who are family and people who live with us. So if they don't cohabit, then the answer would be her prospects of succeeding would be very, very slight. But there are lots of arguments being run these days, Claire, about couples who live in two houses.
Yeah.
And the granny flat, what we're really talking about is planning rules that allow you to put a temporary accommodation property in your house. Right, so in your backyard. Is that what you're talking about?
No, it's a Centrelink rule called...
Oh, okay. Radio.
What's that rule, David? Can you tell us?
Well, the way it works is that what you do is that your parent pays you money to provide accommodation for them. So you may have an extension to your house, you may have some other accommodation. So what they would do is, this works, it doesn't work all that often, but it does work, Claire. So let's say we sell Dad's house, we clear $400,000, and Dad pays the $400,000 to you to provide him a house to provide him somewhere to live for the rest of his life. So, in my view, it works sometimes, but it's fraught with difficulty. The child who gets the money may waste it. The child who gets the money may fall in and have a marriage breakup. The parent who's staying in the house may require long-term care, but no longer has the money to afford that long-term care. But that's what they call the granny flat rule, where you pay money to someone for them to provide you accommodation for the rest of your life, and Centrelink considers that to be like your house.
Okay. Thank you so much for your help and everything.
Thanks, Claire. Can I ask you a question, David? That you were saying there that generally, if you're not living together, you're not deemed to be, requiring support. But many arguments now are made about couples who do decide to live separately. In that instance, how is it judged? Is it judged on a time period of relationship, or? No,
if you are someone's domestic partner, that's a question of fact. You either are or you aren't. Even if you don't live together? Well, it's I've got one client who I know. They're a couple. Well, I consider them to be a couple. They live in one house 3 days a week and the other house 4 days a week. Now, one could complain that they're occupying two houses, but there are lots of people who, also people who work in the city during the week and go home to their partner on the weekend. So lots of different ways to have that couple relationship. Everybody's unique.
Indeed. Well, Jane has joined us from Hampton. Hi, Jane.
Oh, good morning. Just a question. I am a landlord and I have had a tenant here through flatmates.com. He breached COVID rules and he was asked to leave in a hurry, escorted out of here by the police. Now, he's left a bed here and some belongings. I'm wondering how long he has got to collect those belongings before I can dispose of them.
Well, the question, and it's a question of fact, Anne, has he abandoned them? Because if you took the view that if someone was to form the view that they had been abandoned, then there is nothing to prevent you disposing of them. On the other hand, if he's not abandoned them, but for whatever reason that caused him to leave, he's not able to come back and get them.
Yes.
Then it's quite possible that you would use either the disposal of unclaimed goods provisions in the Australian Consumer Law and Fair Trading Act, or you would look you'd look at residential tenancies. And I tend to think it'll be a residential tenancy issue. And if you have a look at the Residential Tenancies Act for abandoned goods and see where you go from there.
Thank you so much, David.
Good luck. Good luck, Jane. Peter in St Kilda. Good morning, Peter.
Good morning. Good morning, David.
Hi.
Good morning.
Good morning, and Ellie, sorry.
It's all right. Go ahead, Peter.
Okay, my problem is, or our problem is that we live in an apartment block in St Kilda. And on the 5th of August, the apartment above us started a large renovation. In fact, they bought the apartment next door and they're making it into one luxury apartment of about 300 square metres. This entailed, for the first 6 days, jackhammering up 200 square metres of tiles for 4 hours a day, for 6 days. They've continued the work despite everything that we've done to try and stop it through the building management. It is very clear from the Victorian government on the Business Victoria website that in apartment blocks, a residential tower will not be considered fully vacant unless the entire residential tower is vacated. So the owners, and that is unless emergency work, such as repairing a leaking pipe.
Peter, what is the building manager doing?
Nothing. The OC managers just say it's a private matter. The building manager just says when we approach him about it, he says it's emergency work. It's emergency work. Now, fitting 3 new bathrooms, kitchens, and a whole new luxury flat is not emergency work.
No, Peter, you could go to VCAT and get an order to stop them. There's probably an issue at council about whether it's work that required a building permit. I do know that breaking into structural walls is a problem, and it will be a structural wall if it's between 2 units because they're expanding.
Couldn't he just go to the police, David? I mean, it's actually breaking the law.
We've called the police, and the police have no knowledge of the current laws. When the 2 policemen came, they went upstairs and saw the owner, who said that they had some permit to do the work. Now, the only permit to do the work, all the business people we've talked to, like master builders, have said that they only give guidelines on this.
Oh, okay.
The police were very clear that they were busy, they had to get on with a traffic accident, and they were only...
Can I understand it? And I have real sympathy for the police. There was a Government Gazette published last night, Peter, and it's Government Gazette number S492, and you can find it at gazette.vic.gov.au, and they are the 114 pages of new regulations that implement the Premier's announcements from Sunday. So look in there and you will find 90% of what you want. But it would be, I'd go to the council about unlawful structural changes to the building, and you could issue your own claim at VCAT with a dispute against an adjoining property.
But any breach of COVID rules is a police matter.
Yes.
Can I say I understand that, Peter, but if you, I have real sympathy for the police. They have an extraordinarily number of rules to operate, but if you were to go and get the regulations, you'd then be in a position to take them down to the police station and say, there's the rule.
Yeah, I think maybe, Peter, you need to help the police out on this one, or as David says, take your case further, maybe with VCAT. And speaking of VCAT, Michael in Coburg, you have a VCAT question. Good morning, Michael.
Good morning. Thank you for your program. David, I think you touched on this last week. It's to do with an enforcement order at VCAT, which I've been granted. And I didn't realise, but VCAT obviously don't enforce that order. I was then told
they have. When I started in the law a long, long time ago, Michael, there was an enforcement process in the Magistrates Court, another one in the County Court, and another one in the Supreme Court. And what we now have is a single enforcement process using the Sheriff, and they do enforcement for the Supreme Court, the Magistrates Court, and the County Court. If you want to enforce a VCAT order, you take a copy of the order to the Magistrates Court. It gets converted into an order of the Magistrates Court, and then you have the Magistrates Court enforcement process. I have no great love for the enforcement process in any of our court systems because they just don't work particularly well. It's a very slow steamroller.
Well, that's my concern here, and I'll try and be as quick as I can. I did take it to the Magistrates Court, and now whether the gentleman there was, it's actually the Heidelberg Magistrates Court, and whether the gentleman there was just unsure of the process, but he turned around to me and said, no, we need the court link number, and we need this, it's got to go on the court link system, and he said, do you have the court link number? I said, well, no, I don't. He said, well, I suggest you go back to VCAT. And I've then copied VCAT in on another email, which now they're not wanting to respond to my email, and said we don't have a written enforcement request for the order. So it seems so arduous, and I said, well, I'm requesting that you enforce the order. It was actually an eBay dispute where the person, I spoke to you about it several months ago, and your advice at the time was perfect, and I got the order granted to me. And what happened, when I took it to the Magistrates Court, he said, we need the court link number. Then only to be told that VCAT, no, we need a written enforcement of the order. Then to go back to the Magistrates Court, he said, no, we need the court link number. So
Michael, I will endeavour to solve your problem for next week.
Okay,
all right?
Michael,
okay.
Gosh, that does sound rather Kafkaesque, doesn't it? But
yes.
Yeah, Michael, David will get back to you on that one. That does sound very difficult. A couple of people have texted David to say that if you've got a breach of COVID building rules, you can report it to WorkSafe.
Okay, perfect.
That seems to be one avenue that you can go down. Jane in Elwood. Good morning, Jane.
Ellie and David, thanks for taking my call. I've had allegations of bullying and misconduct brought against me and a letter from my boss. And I was wondering what course of action I have as the employer hasn't followed the disciplinary procedures that are outlined in the company policy and our employee handbook.
What do you think the employer is supposed to do and hasn't done?
Right. So I'll read you two excerpts. The first one says, you will only be disciplined after careful investigation of the facts and the opportunity to present your side of the case. And the second point is, at all disciplinary hearings rather than investigatory meetings, you have the right to be accompanied by a support person at all stages of the formal disciplinary process. So to get back to point one, you'll only be disciplined after careful investigation of the facts and the opportunity to present your side of the case. The first instance I had of allegations of misconduct was an email that was sent to me last week that said, we have received a formal complaint from an employee under the bullying policy, and as such we are inviting you to a disciplinary meeting to allow you the opportunity to respond. So point one says you'll only be disciplined after careful investigation.
So it's a description of the meeting.
A disciplinary hearing is not the same as the application of discipline. I actually have a fundamental problem with their statement. Because it seems to me, but what they're saying is that there will be disciplinary processes after the hearing. I would have come along and said there'll only be disciplinary processes depending upon the outcome of the hearing.
Yes, so it says they said to bring a support person. So they said in the letter, if I could just sort of fill you on everything. So then in the attached letter it said invitation, dear Jane, invitation to disciplinary meeting. Then they outlined the 4 allegations of misconduct, and then further in the letter they said, we request your attendance at a disciplinary meeting. And then it says this disciplinary meeting is to be conducted at whatever date. And then it says you are, of course, welcome to bring a support person to this meeting should you choose. So I brought my support person, but I'm referring back to point 2 before, that it says at all disciplinary hearings rather than investigatory meetings, you have the right to be accompanied by a support person. So they've jumped, as far as I'm concerned, past the investigatory stage and invited me to a disciplinary meeting without my chance to be investigated, without a support person.
Then why would you not go back to them, and Jane, and engage to them on the language? I think they're trying very hard to do it properly. I think the issue is one of language. Is this to investigate or to impose an outcome?
Well, the thing is that I did go back to them, and now they're saying, oh no, we were going to investigate. But the thing is, they've brought 4 allegations towards me that one of them is I didn't say I was going to a lunch break. There were 4 points. The second point was I didn't fill in a spreadsheet.
None of those appear to me to be in the nature of, they might affect your work performance, but they're not bullying.
So what does Jane do? We're going to run out of time on this one.
Okay, so I guess quickly is that I feel like they haven't investigated it without my support person. They've gone, straight to disciplinary.
No, can I say I'm not convinced that's right, Jane. It may simply be poor language on their part.
Well, it is.
And I would be asking them to split the bullying and the misconduct allegations and actually work out what they are. And I do think that your support person will be attending the investigation meeting. What you might like to do is ask them...
We've already done that. It was a disciplinary meeting held yesterday.
What can I ask, Jane, what made it a disciplinary meeting as opposed to a meeting with a disciplinary title? Was it a meeting at which we endeavoured to investigate, or were you asked to respond?
Well, they've used the noun, we're inviting you to a disciplinary meeting.
But what happened in the meeting, Jane? That's the key. Were you disciplined or were you invited to respond?
I was invited to respond.
I think the problem is really, Jane, one of the language that they're using, and I can't fix that problem.
No, it's
but you might go back to them and say your problem, you have a poor exercise of language because it was a meeting as part of the investigation process, not the discipline.
Jane, we wish you well. It sounds, doesn't it, David, like they're trying to do the right thing, but maybe not getting their linguistic ducks lined up appropriately. David, thank you. I'm going to let you go because we need to get news headlines before we have to go to the Premier's press conference. Thank you, David. David Whiting there, Melbourne solicitor, answering your queries.